Hello, everyone. My name is Kristen Cranbeer. I am the Advocacy Program Coordinator for the Archivy Central Iowa. And we are very excited today to have our guest speaker, Frank Varvaris, with us. Frank is the proprietor of a firm in Cedar Rapids, and he provides planning assistance to people with disabilities and their families. He's been working in this field since 1990, and his office has clients from all over the state who contact him for his help. We will be providing this assistance today and some attachments via email. And so you will receive those after the interaction that we have today on this call. The handouts will contain a background sheet about Frank, and this will be sent to all of you. The information will give you a clearer picture of who Frank is and the kind of professional work that he provides to individuals with disabilities and their families. And as we start this process of preparing for today, we're excited to have you all here joining us for further discussion and interaction. Today, he's going to be presenting his workshop presentation on estate planning for people with disabilities, which will also cover Medicaid, Medicare, and Social Security disability. I'd also like to add that Frank has been a part of the ARC for 30 years. He is the past board president, and he has also served as our foundation board. Frank has also served as the Early Childhood Council, Iowa Brain Injury Council, Iowa Statewide Independent Living Council, and Discovery Living, and more. For your information, Frank wrote the law in Iowa about special needs trusts for people with disabilities. He's a valuable resource, and I know that you'll find his information helpful. It's with great pleasure that I introduce our guest speaker, Frank Varvaris.
Thank you very much for that kind introduction, Kristen. As Kristen mentioned, my name is Frank Varvaris. I've been providing disability planning services throughout the state of Iowa since 1990. A few of those services that we provide are the estate planning for people with disabilities, Medicaid spend down strategies. We help clients apply for it and qualify for SSI and SSDI. My office is an approved EN, which stands for Employment Network, through the Ticket to Work program. So if we win a claimant case and they are receiving benefits, we can help them get back to work, even if it's on a part-time basis, and we understand what the rules are regarding income and how that income could affect their benefit package. I also have a subsidiary corporation called Life Planning Administrators, which manages some special needs trusts for clients. So in a nutshell, those are the core services that I provide. And lastly, I might mention, I've been having a number of people that their spouses are going into a nursing facility, and the community spouse, which is the individual living at home, isn't really sure what to do in order to preserve the assets in their estate. So we help them do the strategies to ensure that they're not going to lose all their money, and we help them, their spouse, become eligible for Medicaid Title 19 coverage. So what I'm going to do today, as Kristen had mentioned earlier, is talk about the estate planning concepts that parents can use when planning successfully for their child who has disabilities. And Kristen had mentioned to me that the audience composition today will be parents and also social workers. And I'm glad that we have a mix like that, because it's extremely important for parents to gain this information. A lot of this they can do on their own. And it's good for social workers to gain this information, because then you have information that you can pass on to clients when they have questions that they ask you about typical estate planning for their son or daughter. So let's move forward here. I can. And for some reason, this just got stuck here. Just a minute. There we go. Okay. I'm going to turn off my screen here. and let everyone focus on the slide presentation. Okay, my agency is an independent office providing specialized planning assistance to all people with disabilities and their families. I've been doing this since 1990. The office is not a law firm, a tax agency, an agency of the state of Iowa, or federal government. However, we are an approved provider through the EN Ticket to Work program. Furthermore, my office is not owned by, part of a bank, a subsidiary of any financial corporation. We have absolutely no captive relationship with any of these entities. What I'm going to do this afternoon is talk about some basic estate planning concepts to ensure your child's future needs. We'll talk about benefits, and we'll use Social Security as sort of a spin-off, because a lot of the benefits that are provided to a person with a disability follows the methodology for eligibility for Social Security benefits. We'll talk a little bit about the financial planning aspect, safeguarding money for your child using what's called a special needs life enhancement disability trust, which conforms to Iowa Code 634A. Now here's a quote. To grow old is human fate. It confronts our handicapped sons and daughters as it confronts us. We can prepare ourselves for this, but we must prepare our children. Now this is a 40-year-old quote. The word handicap, of course, is antiquated, but the point here is families typically have a procrastination when we talk about estate planning, because we're talking about our own eventual deaths. But it is important, if we are parents that have children with a disability, we do some planning in advance and develop a game plan. Otherwise, what happens when we are deceased, we have case managers and staff with the DHS that move in to help with making decisions for our child, and they may not know specifically what it is that we want to accomplish for him or her. So we're going to start with some basic estate planning terms. The word estate planning is really a generic term. People refer to it as luxury planning, inheritance planning, tax planning, but it really involves nothing more than integration of four things. Number one, knowing that at some point in my life I'm going to die, to whom or what do I want to benefit the assets in my estate? Number two, what are the best means to pass my assets to those individuals? Thirdly, what is the most cost-effective way to create or conserve money when needed? And then lastly, what are the tax consequences of my actions and how can I improve upon them? That is really what estate planning is all about. And we've got people that travel throughout the United States hobnobbing with the wealthy, talking about all these different maneuvers they can make from an estate planning standpoint in order to minimize taxes, because they don't want to pay for that money to the government. When we're talking about providing for the welfare of a person with a disability, the estate planning is different. It requires a sensitivity to their needs, a good working knowledge of county, state, and federal government benefit programs, and then a service delivery system that's comprehensive, yet is easy enough to get through so you understand and can complete the job. Planning can be a little difficult if you're a parent with a child who has a disability, because if the child is receiving benefits and programs provided by the county, state, and feds, there are different eligibility rules that they have to adhere to. The first one is a lot of the programs follow what's called the $2,000 resource limitation. Other programs follow a higher resource limitation, but at some future date, that resource limit can change back to only $2,000. Eligibility guidelines for services may differ from county and state versus federal, as I mentioned earlier. Sometimes income guidelines can affect eligibility. Some of these programs that we use follow what's called the 300% rule, which is nothing more than 3 times the monthly amount of the SSI payment. And some benefits are means tested while others are not. Case in point would be SSDI. That is not a means tested benefit. Personal life planning is a form of estate planning, but yet it's a little different because we're focusing in on the needs of an individual that has special needs, some type of a disability condition. And in the past, working with families over the last 30 years, I've come to realize there's typically about 6 different concerns that mom and dad have for their child that has a disability. The first one is, how do we plan successfully to provide lifetime supervision and care? That's normally a concern that parents have. Now, they may not have all 6 of these concerns, but they may have some or 1 or 2. Second area of concern is maintaining government benefits and assistance on the county, state, and federal levels for medical care and basic living expenses. Whoop. And I'm going to touch on the 4-part individual Social Security entitlement because, as I mentioned earlier, a lot of the programs and services provided to a person with a disability follow the eligibility methodology for Social Security. So this is going to be quite rudimentary. I'm going to try to get through this quickly. Hang in there with me. The Social Security Act was signed into law in 1935, and it was signed into law specifically at that time for wage earners that were working, paying into the system with the intent that once they reached age 65, which was retirement age back then, they would have a payment made to them, and that payment, which back then was a lump sum payment, would be an adequate amount of money so they could enjoy their retirement the rest of their life. Well, that's obviously now the way things work now. Retirement age has shifted beyond age 65. Full retirement is age 66, closer to age 67 for younger adults. Now, in 1965, the government created Medicare healthcare coverage. And this is an important component because without that, the majority of people that are elderly would not have any health care. It cost them too much money. And this was during the Vietnam conflict. President Johnson signed this into law. Going back to Title II, the Social Security Act, in 1939, Social Security discovered, or Congress did, hey, we haven't been kind to provide benefits for the stay-at-home spouse. And when the entitlement was enacted in 1935, the socially accepted norm was dad went to work, usually to the factory, made some money, and then mother stayed home with all the children to raise them, feed them, and take care of them. Well, Social Security determined that was unfair, so they included a spousal benefit in 1939 to make sure that a spouse who may not be working would be eligible for benefits based on their husband or wife's earnings record. In 1966, the government changed Title II again, amended it, and opened up disability benefits for a insured covered individual, a spouse, and a married individual that has been paying into the system. And if they're found disabled, their children under the age of 18 will receive benefits. If they are deceased, their children will receive benefits. And it opens up an estate planning opportunity so that if the child who is found disabled prior to age 22, they will get an income stream when they turn age 18 based on their parents' earnings record. I went through that pretty quickly. I want to make sure you I didn't lose you there, but I wanted to get through this so we could go to the next slide. Now, there are people that have never paid into the system. My office is in the Cubias building. I'm right across the hallway from the Cedar Rapids Transition Center. And the kids at the Transition Center are applying for SSI benefits. They don't have a lot of earnings record to pull an income if they're found disabled from Social Security Title II. So in 1972, the government created another bag of money called Supplemental Security Income, SSI, Title 16, which pays a payment to an individual found disabled under the Social Security Act that didn't pay into the system. In Iowa, if a person has any SSI money at all that they receive from the federal government, they also receive Medicaid Title 19. We're what's called a 1634 state. The maximum SSDI benefit is $3,345 a month. Maximum SSI benefit is $841 a month. The two components, supplemental security income and Medicaid, are important for a person who has a disability. But the catch is, in order to maintain eligibility for those components, the client in general terms can never have more than $2,000 in resources. So if you think about that, you're a young audience. If you could work to retirement age, and the caveat was you can't have more than $2,000 in your savings, that might be kind of a scary situation. But that's the way it is right now for people who have disabilities. Third area of concern that parents address is how do we guarantee supplementary funds to ensure that our child will enjoy a meaningful life? How do we manage those resources so that there will always be supplementary and discretionary funds available? And then how do we avoid or at least minimize family conflict? Lastly, providing for dignified final arrangements. As I said before, these may not all impact the clients with whom you work or parents that are in the audience, but a few of these might, and that's what we try to address when we do planning in advance. Now here's an estate planning distribution slide. And I use this slide because it has a smaller size estate. And I don't want people to think they have to have assets like the Kennedys and the Rockefellers in order to do estate planning. But in this scenario, we have mother and father, they have 3 children, loving each child equally. They left equal shares of their estate to child A, 70,000, child B received 70,000. The child with the disability received his or her fair share, but what happened? They lost their Title 19, Medicaid, waiver services, county assistant, SSI, until that inheritance money was spent down to the $2,000 resource level, at which time benefits were reestablished, but there was no money left for them to fall back on if they needed assistance or an emergency. Personal life estate planning consists of 5 separate and equally important steps. Number 1, we go through what's called futures planning, making decisions in advance, which we'll discuss. Financial planning, legal planning. Fourthly, program finalizing. And then lastly, maintenance planning. So let's start. I'm going to touch on those. We want to create a safe continuum for your child. So in the past, families would go to Social Security. From there, they'd be referred to another agency, the DHS, nonprofits, an attorney, CPA, some financial advisor, a bank. Well, by the time it was said and done, a lot of clients would get overwhelmed with that process and would never complete it. So with the assistance with an experienced planner, we can simplify things for clients so that they can get through it and complete the process. So let's talk about the first step. If your child is living at home, you know more about your child's unique qualities than anybody else. We've got professionals such as medical providers, therapists, psychologists, people with the AEA. We've got individuals that are special ed teachers. All of those individuals have paused, taken a look at your child, and then they go about their life. The true constant that your child has are mom and dad. So what I'm suggesting is when we do planning, parents take out a legal pad, write down these various categories, and I recommend you do this with all parties that can be involved in this planning. It should be other children, siblings, grandparents, anybody that you want to discuss this with. You create a continuum, and most importantly, include, if your child is capable, input from him or her, because he is the most important part of this planning. So the first area we would consider is future living arrangement. And I've had clients that would come into the office and would say, Frank, I think we've got this taken care of. If something happens to us, Dorothy's already determined that if we die, she's going to go live with her brother Mike, who resides in Minneapolis. Okay, that's fine. We can build that in as an option. But maybe when parents die, that isn't the best option. Maybe Mike's going through a divorce, or he just got laid off from work, or his spouse is having health problems of her own. Well, rather than force Mike to accept this responsibility because of a moral obligation, let's build in some other options to make it as deep as possible, so no one has to take on a responsibility unless they actually want to do so. And that way, everything is in a positive position. Another area we would look at would be employment or meaningful day activities. We would discuss that openly and create a list. Social leisure should be discussed. Medical care. I've got a client. She swears that the name brand drug that her son takes works better than generic. Well, I'm not a pharmacist, so I don't know the difference, but that gives her peace of mind. What I'm suggesting is if that's something that she wants to continue to provide, let's make sure that is written in what's called a continuum plan for your child that we will eventually share with other people. Personal needs assistance should be addressed. Religious environment should be addressed if that's important regarding your denomination, your mosque, your temple, whatever. Final arrangement. All of those should be addressed openly with other family members to create a written continuum plan. And then you share that plan with guardians if appropriate. And the reason I say if appropriate, maybe the child is not in need of a specific guardian. Maybe they are higher functioning, and we should look at some other less restrictive services. Family members should receive a copy of the continuum plan. Relatives, friends, advocates. I have some clients that share it with their clergy, share it with their primary care physician. People who will know and understand what it is that you want for your son or daughter's future. They can all have a copy of that. And sometimes I refer to this as a letter of intent. The second step in creating your child's personal life plan is financial planning. Now, unfortunately, I'll have clients that will come into my office and they think that I'm going to tell them what mutual funds to buy or stock to invest in. It's not that at all. The question is, what can we use in order to maximize benefits and money available to provide for your child's future? And the first thing we want to maximize is government benefits. Now, what would be an example of a reduced benefit? An example would be if you have a child receiving SSI benefits and they're not paying their fair share of living expenses to live with parents, what happens? SSI will create the 1/3 reduction benefit. So that child's lost 1/3 of their benefits from SSI because they're not being charged their fair share. Maybe we should charge the child his or her fair share, maximize the benefit, and then use that money that your child has paid you to do planning, legal work, and use it as a funding stream for your child's future. Another area we would look at, family assistance. And I'll have families that will say, well, you know, grandpa's got a $10,000 CD earmarked for John. Well, that's fine. We can use that, but we're not necessarily going to just rely solely on that alone. Could be that maybe grandpa ends up going into a nursing facility and that $10,000 is spent down for Medicaid assistance, or just as bad, Grandpa dies, leaves the money directly to his grandson. And because he's over the $2,000 resource limit, we have to strategize ways to protect the money. And normally and oftentimes it can be spent down and we lose it. Inheritances should be addressed. Savings, investments, insurance can be used successfully. All of these can be used in addition to anything else that we would want to suggest. So when we talk about developing this program, we want to take a look at the government benefits for the child, and then we determine how much additional money will be needed to meet the goals that you want for your child's future. And if the government benefits, which typically are not enough, then we have to take a look at how are we going to have additional monies available to solve for the difference, or will we change our goals for our child's future? The third step is creating legal planning. And what do we do here? You meet with an attorney, and I want you to ask the attorney these points. Number one, have you done this work before? Are you willing to learn? How much do you charge? How long will it take you to get it done? And will you make this a collaborative effort? And the reason I say a collaborative effort is we have an individual who has a disability, and maybe they're unable to do specific planning on their own, so they're relying upon mother and father, a planner, and then a legal practitioner. Nobody should have egos that are bigger than that child. The child is the most important focus of this planning. So we are there to support the needs of the individual and develop a program that will surround his or her future. The legal work should include updated last wills and testaments for both spouses. Even if the divorced spouse is not paying attention to the child, we need to see if we can bring them into the picture and have their wills updated. We exclude the person with a disability by name, but we leave that share of inheritance to a special needs life enhancement disability trust. The Life Enhancement Disability Trust is used to protect government benefits, provide supplementary needs, include discretionary language to supplant government benefits if those benefits do not enhance the child's life and provide for independence, make reference to the continuum letter, include a trust protector, which I'll discuss briefly, and then to assure a quality of life that is safe and comfortable. That's the goal. Let me share this with you. There was a case, two trustees, they were co-trustees, Harvey Platt, who was an attorney in New York, and J.P. Morgan Chase. They managed a special needs trust for a young person that had autism. And they managed that trust for over 10 years. The money grew to $3,600,000. Now, I have no trust in my office that are as large as that. But this young man had a very large trust. Well, in 2012, Attorney Platt approached the court because he wanted to become the guardian of this young man. And the judge said, well, why are you wanting to become a guardian, Mr. Platt? And he said, well, it's only natural and normal that I do because I am the attorney that drafted this trust for this young man, and I am the trustee managing it with Morgan Chase Bank. And so the judge said, well, let me see a copy of that. And then she said, how much money have you actually spent out of this trust? And he said, well, we haven't spent any of it over the last 10-year period. She said, well, why not? He said, well, I don't know. And then she said, but yet you want to be the guardian and look after this individual's interest. I want you to start using this trust properly. So what they did is they hired an individual to act as a care provider and check on this person. They paid the care provider for their involvement, and then they spent about $3,600 for the individual with autism, and they charged a fee against the trust of $78,000. Now imagine that. The child with the disability got basically very little value from this trust that his mother had created for him. The judge said, you put that money back, you don't deserve $78,000. And I thank God in this scenario that the attorney actually went to the judge to ask to become a guardian because she caught what was going on and now is scrutinizing whether or not the use of this trust has been appropriate and suitable for this young man over his lifetime. When I wrote Iowa Code 634A, I did so because attorneys 30 some odd years ago didn't know what a special needs trust was. And I thought, you know, what the heck, if I can at least draft the bill, submit it, get a sponsor, and then have it approved by the Iowa House, the attorneys will at least have a reference to go to, knowing that we have a bona fide law in place to protect these trusts. It doesn't mean that the trust will be written properly to provide the maximum benefit to the individual. It just means that we can protect it. So it's important to take a look and make sure that the language in the trust will impact your child favorably. Here is the original slide that I showed, parents loving each child separately or individually. They each received fair shares of the estate. The child with the disability received their fair share, but what happened? They lost their benefits because they were over the $2,000 resource level. Here's the way it should and can look. Same situation, child A received their 70 grand, child B received their 70,000. The child with the disability received their 70,000 that went directly to their life enhancement special needs trust. Monies were used to enhance the person's life. And then what happens at the death of the individual, that person who has the disability? When they die, typically, monies will revert back to the siblings, but 99% of the clients with whom I work will leave a sum of money to a nonprofit that has served them well. It can be the ARC, it can be brain injury, it can be a local hospital, it can be your church or synagogue, it doesn't matter. And then the remaining monies can be dispersed to the other two children. Things to think about. In planning, I've worked with families that have the 3 children, and 2 of the kids are professionals. Maybe they're medical providers, surgeons, brain surgeons, and earning close to $1 million a year. Well, maybe they don't need quite as much money in that inheritance as the child with the disability does. Maybe he or she needs more of the inheritance from the estate, knowing that at some future date, the monies are going to eventually revert back to his brothers and sisters anyway. Just things to think about. This is the quality of life slide. On the left is what the government provides to a person who has a disability. Some care and supervision, medical care, employment opportunities, basic personal needs through supplemental security income, state supplemental assistance, Medicaid, and Medicare. This is what the trust can continue to provide following parents' letter of continuum, advocates, guardians to look after the person's best interest, additional medical care, dental care, vacations with relatives, gifts on special occasions, self-esteem items, basic care if there are government cutbacks. All of these and more can be included when we develop a well-written program and create money in advance to have for our child that has a disability. Now that is the planning that I typically go through. I included some additional slides. If I can touch on those just for a moment. Let me see. Sometimes I'll have clients that come into the office and they're talking about they heard from some financial investment person that they should be moving money around so they can keep their child on Medicaid or themselves. And I suggest you have to be very careful because you can open up penalty periods, and the DHS doesn't like people moving money around in order to qualify for Medicaid. I won't use that. ABLE accounts should also, in my opinion, be considered as an option for planning. And I don't know if you know what an ABLE account is, but that is an account that was approved by Congress in 2015 or thereabouts, where people with disabilities can actually take their own money and put them into these accounts, and that money won't count against the $2,000 resource level. The flip side of the ABLE account, unlike the special needs life enhancement trust, at the death of the client, the monies in the ABLE account goes to reimburse the state for Medicaid expenses paid on their behalf. The special needs trust does not. It goes back to typically the brothers, sisters, nonprofits, hospitals, so on and so forth. Every state that receives federal appropriation through Medicaid must create a Medicaid recovery agency. And we have one in Iowa. It's run by Ben Chapman, and he scrutinizes Medicaid recipients at their death to see whether or not there is any reimbursement that they should attach or go back against the estate. I won't get into that. I will touch on this. All right, so if you are going, number one, if you're going to apply for life insurance, for your child who has a disability. Make sure you apply for coverage with an insurance carrier that has liberal underwriting that will insure your child. Otherwise, what happens is when an application is submitted with an insurance company, they have these codes that goes into the some department, and those codes specify certain things about the individual. And if the person is denied coverage and they apply again with another insurance company, the new insurance company can access those codes to see if he or she's applied in the past and whether they were approved. Okay, that's one thing. And we have lists of carriers that will look at that. The other thing is, if you are, as a parent, currently have insurance on your child, you took it out when they were a youngster, you're paying the premium, you're the owner. You should know that once the child reaches age 18, ownership typically reverts back to the child unless you are listed as the irrevocable owner. If the monies in that policy exceed $2,000, he or she won't receive SSI, and they could get knocked off of Medicaid. So that's important. And then here's the last thing on this. I had a lady referred to my office a number of years ago. Her son, she lived in Benton, Iowa, Benton County. Her son was in a car accident, a sustained traumatic brain injury. Well, she didn't want him to go to a nursing facility because she didn't think that that was appropriate. So, but she had heard about the brain injury waiver. So she met with the income maintenance worker at the county and went through her son's finances. And the income maintenance worker said, well, your son's not going to qualify because he's got this $60,000 life insurance policy that's got $3,500 in cash in it. So she said to the mother, he needs to go out, cash it in, and then spend the $3,500 and then come back to see me and we'll proceed with an application. So she ended up in my office and she said, what do you think of that, Frank? And I was troubled with it because I said, I think it stinks because we're taking this big insurance outfit off the hook for a $60,000 death payment. And the chances of your son getting standard insurance anymore are probably slim. Here's what we're going to do. I submitted forms to the insurance company and transferred the ownership of that policy to the mother. Okay? Well, that's a no-no because that's called a transfer for lesser than fair market value, and DHS doesn't like that. So what did we do? Well, I had the mother take from the policy the maximum loan out of $3,500 and give it back to her son. Now, her son still doesn't qualify, does he? Because he's over the $2,000 limit. But what I had her do is she went out and bought a computer for him, some programs to engage his mind, some new clothing. So she spent $2,000 on things that he needed. The remaining $1,500 she put into his savings account because he could have up to $2,000. So what we did is we salvaged that insurance policy. The reason I share that story with you is sometimes, myself included, when I'm talking to the DHS, I'll have a bureaucratic answer that is from the text that has absolutely no positive bearing on what I'm trying to accomplish. And I want parents especially, and social workers as well, if you hear something that just doesn't sound right, get a second opinion. There may be another option that we can go to that will better perform and meet the needs of the individual that we serve. So let's see. That's my favorite slide. I've used this for 30 years. Excuse me. That is the completion. It looks like we have 8 or 9 minutes left, Kristen.
Wonderful. Thank you so much, Frank. I get excited every time that we have an opportunity to hear you speak and be able to share the wisdom that you have. If anyone has questions, you can enter those into the chat, and Frank's happy to answer those for you. You know, as you were talking and running through everything, Frank, it kept making me think about a conversation that we had as we were preparing for this event. And just about, it's really important that we kind of get out of this mindset where we are just being reactive. We have to be proactive. And it's really important that we stress that with our families, the importance of being proactive in these moments. I think about how many conversations that probably those who are in this field, who are on this call right now, are having with family members. And when you are just doing a regular annual meeting, you're touching base with them and you're asking, hey, what's the future plan if, something were to happen to you? And so many of our families don't have a plan in place. And really what that impact is to their loved one not having that plan. So just reiterating the importance of, it's common for us to see, but we really need to have our families have game plans. And if anyone has anything that they want to add in the chat, or they would just like to have a little bit of additional information on whatever those questions might be, feel free to put those in the chat, and Frank's happy to answer any of those questions that you have.
Yeah.
It looks like right now we don't have anything coming in. We'll probably give it another minute or two. Frank, is there anything in particular extra that you want to touch base on?
Well, I normally send out updates on Social Security, and we're going to have a cost of living adjustment, a COLA, that will go into effect January 1st. And from what I hear, it could be as high as 8 to 10%.
Oh, okay.
Now, I don't know if that's true or not. I've made my contact with Social Security, and they don't seem to know at this point. But that seems to be a nice increase if, in fact, that materializes. In addition, for people that have Medicare Part B coverage, the premium is going to go down roughly $5 per month.
Okay.
So those are good things.
And it looks like we have a question. So is there an average cost to establish a special needs trust?
That's a great question. I've seen attorneys charge anywhere from $1,400 to as high as $3,000. I would say special needs trust should not, parents should be a little leery if the attorney with whom they're working is going to charge them over $1,500.
And I think it makes sense. It's one of those situations where do your due diligence. And if you have family who, they may know someone, or if you have another parent who's a friend in this community, I always think referrals are a good way to go. Oftentimes people will call the ARC and will ask us, and we will recommend, and the recommendations that we make are based upon those interactions that we've had already with other attorneys who are in our area. We do have another question. Is there a brief handout information we can carry with us? So as coordinators, as case managers, the information that you're going to share, Frank, and those handouts, are those things that our staff would be able to share out in the community
Absolutely.
with families?
Sure, you can make copies and share it with your, the consumers with whom you serve. Absolutely.
Perfect. That's wonderful. That's something I know will help. Oftentimes case managers, coordinators, they're really there having some of those in-depth conversations and don't always know where to turn or how to turn. So I appreciate that. And I know that they all do as well, being able to have that information. And it looks like we have a couple minutes left, but no other additional questions coming in. We have thank yous for you coming and speaking today. So we appreciate that. And I just want to put a reminder out there, October 19th, we get to have some time again with Frank, and we're going to be talking about applying for SSI and SSDI. So if you haven't had an opportunity to sign up and register for that event, we would love to have you. And you can just send me a message directly, or you can visit our Facebook page, and we have an event set up for that. You can click and register with that Zoom link. But again, Frank, I just want to say thank you. We appreciate it so much. We're going to have this recording. We're going to make it available to anybody who would like to access it. If you registered for the event today, you're going to get it via email. In the next couple of days, we'll also have this posted on our social media, and it will go out to an e-blast. So if you receive communication from the ARC, this is going to go out, and really, it's such an important thing. And we're grateful to Frank that he wants to spread this message and share it with as many people as we can. And if you have questions or need further assistance, please contact Frank. He'd be more than happy to support you.
Thank you very much, Kristen.
Yeah, thank you all so much. I will give you a couple minutes back into your day, and we hope that you all have a wonderful day.